my lords, my lady. We were
yes, we were going to look at Dicey.
Dicey, yes. So that's Authorities Bundle tab 8, and it's at the beginning of that tab, at the page. We'd looked briefly at the rule 64.1 on page 160, and then I was just going to take my lords and my lady to paragraph 16.008 on page 163, which is headed Law Governing the Arbitration Agreement. In fact, actually, if we can start on the page before at 1607 at the bottom of the page. So it says, 3 distinct issues of governing law may arise in international commercial arbitration: the law governing the arbitration agreement itself, the law governing the arbitral procedure, and the law governing the substance of the dispute. And it starts with the law governing the arbitration agreement at paragraph 16.008. And if I could just ask my lords and my lady to read that, that would be helpful.
Yeah.
And so really, I rely, as I've already, I think, made clear on the first line, that it's the law that governs the validity, scope and interpretation of the agreement to arbitrate is the law governing the agreement. And that is obviously an issue of practical importance because it affects the question of the jurisdiction of the arbitrator. So the question is here, does the Los Angeles arbitrator have jurisdiction? And we say yes, because of the effect of the arbitration agreement, which is contained within the 1997 agreement, which is therefore governed by California law. And so there's 3 things mentioned there: validity, scope, and interpretation. And if my lords and my lady turn to page 246 now, which may or may not be behind another tab, it's a good chunk of pages on, then there's the updater to chapter 16, which has, as my lords and my lady have already seen, an update to rule 64, making clear that the law applicable to the arbitration agreement also governs the question of who is a party to it. And then there's a reference to Edgy Azarian, which I'll come to in a minute. But the point I make here is, essentially, the law chosen in the arbitration agreement is the law that governs the validity, scope, interpretation, and parties. And so whilst it doesn't explicitly use the term, you know, what's the law that governs whether it's binding on someone, that is encompassed in my submission in the issues of validity, scope, interpretation, and parties.
But you'd have to say, is it binding by reason of some event other than the entry into of the arbitration agreement itself? Because without the assignment of the trademarks at the start of the 1997 agreement, it's quite clear that the claimant was not bound by it. So it's not just a question of it's whether it's binding as a result of some other event or transaction or whatever.
Yes, I mean, that, as I think I've already said, there's 2 aspects to it when we come to look at the Californian law. There's the assignment and Clause 12, and we've already looked at Clause 12, and Clause 12 says that it's binding on assignees. The agreement is binding on assignees. Yes,
so
that is part of...
As my lord pointed out, you don't even get to first base unless by its terms it says so. So it still is the second question. It's whether, by reason of something other than the agreement itself, the agreement is binding on a third party.
But in my submission, that even if one takes it as logically 2 steps, it is still clear from Dicey, when you consider, for example, that the question of whether someone is a party is subject to the law of the agreement, the law of the arbitration agreement, then that is decided under the law of the agreement. So my learned friend has this point that I'm applying circular logic because I'm not asking the prior question, which is, does the agreement apply at all? what Dicey explains to you is all those questions surrounding the agreement, including whether you're a party to it, are subject to the law of the arbitration agreement.
But I suppose we came into this probably when I picked up that it's undoubtedly true that if you just take an agreement and say, is it valid, what's its scope, how do you interpret it, and who are the parties to it, then the law governing the agreement applies to the determination of those questions. And that's what Dicey, I think, is primarily talking about.
Yes.
Our case is a different case, because if that's all you had, you would have nothing, because we know that at the start the claimant was not a party to the 1997 agreement.
Well, I would still have clause 12 of the agreement, though, which in my submission you can still look at, and you have to look at that under Californian law, because the parties to the original agreement clearly intended that to bind the assignees, heirs, successors, etc. And they wanted that question to be decided under Californian law, because that's what they made.
The question, I suppose, is, does that apply to both limbs of the test which we identified before 1 o'clock? The first limb, i.e., is Lord Justice Snowden mentioned in the agreement as a matter of interpretation, and then secondly, is he bound?
Well, I mean, I suppose I would make 2 points. I'm not sure that it's appropriate. Well, in my submission, it's not appropriate to take 2 steps, and there's nothing in Dicey or the authorities that suggest that there are 2 steps to be considered. Every time when you're looking at this question of whether it's binding or not, you're looking at the law of the arbitration agreement. And so in my submission, there's nothing to support the taking of 2 steps. And one also has to look at the alternative approach of my learned friend and see whether that's a good approach or not. Because my learned friend has said, oh, well, it's all terribly straightforward because you've got a UK or EU trademark, then that's the law you look at. And as I'm going to come on to now, actually, that's not what Dicey says. And so in my submission, that approach doesn't work for my learned friend. I mean, perhaps I'll just quickly turn up, if my lords and lady don't mind, I'll quickly turn up Briggs, and then I'll come to that point about Rule 135 and why that's definitely not the correct approach.
Are we going Briggs, do you say?
Yes, Briggs. So that's in tab 7, page 155. And it's just the end of the middle paragraph that I rely on. I accept, as my learned friend points out, that the paragraph generally is about the specific example of insurance, but the statement is made more generally at the end of the paragraph. This makes sense in the context of arbitration, for the question whether there is a valid and binding agreement to arbitrate is an unambiguously contractual issue, and only ever a contractual issue. So, I mean, here my lord and lady will appreciate that Professor Briggs is talking about actually the Civil Jurisdiction and Judgments Act and Article 23, but then he talks here about arbitration at the end of this paragraph and makes the point that in the context of arbitration, the question of whether there's a binding agreement to arbitrate is a contractual issue. And that, in my submission, makes sense because obviously the agreement of the parties to arbitrate and whether that agreement is binding and who it binds and so on all flows from the original arbitration agreement. So I am going to come back to Edgy Azarian, but what I wanted to look at now is...
When he says unambiguously contractual issue, what does the word unambiguously mean? And does it mean there can be no other possibility, no other possible issue which it could be?
Well,
if that's the case, he's simply again dealing, isn't he, with a singular contract with nothing else required to raise a question. And that's different from our case, isn't it?
Well, I don't think he is dealing with a singular contract, because obviously he is talking in the context of insurance, so it's not a totally straightforward case.
He starts his paragraph with the phrase "by contrast," so you've got to see what is he contrasting that with. He's contrasting it with Article 23 of the Lugano Convention and third parties.
Yes, indeed.
And so in the middle paragraph on the preceding page, page 154, he's talking about the question posed by the Convention, which is whether the new party has, as a matter of national law, been substituted for or has succeeded to the position of the party who made the agreement on jurisdiction. So that's the topic that he's discussing. And he's saying that in the context of the Lugano Convention, it's a question of national law. By contrast, he says, in the case of an arbitration agreement, it's a question of the law which governed the arbitration agreement. That's the contrast that he's pointing.
Yes, indeed. And I would pray that in 8, and indeed the heading that mentions third parties. I was going to move on now, but I don't know whether my lords and my lady are still mulling over that passage. So what I wanted to do now, so I dealt first with the part of the judgment where the judge said that Rule 64 was the correct rule to apply. I'm going to go back now to the judge's reasons why he said that Rule 135 does not apply. And so that's in the judgment, starting from paragraph 44. And I'm just going to go through that relatively quickly and then turn up the relevant parts of Dicey. And so, first of all, the judge cites the Rule 135, and then he points out at paragraph 45 that my learned friend focused on clause 2. So that's the rule that starts, in other cases, the validity and effect of an assignment of an intangible may be governed by the right, by the law with which the right assigned has its most significant connection. And he pointed out, as I say, at paragraph 45, that was what was being relied on primarily by my learned friend. He then pointed out that my learned friend also relied on some particular commentary, but the difficulty with the commentary, as we'll come on to see in more detail when I actually come to Dicey itself, is that Dicey has a very difficult job in this section of establishing any general propositions of law whatsoever, actually, because it's all so complicated. Hence, I think that the learned judge's perhaps rather tongue-in-cheek comment that the commentary begins encouragingly with this observation, which is that the choice of law rules which govern assignment and transfer are not easy to state with certainty. And then he goes on to cite paragraph 24.051, which was relied on. And that refers to the fact that intangible property may have ownership recorded on a register. So for registered trademarks, they'll be recorded on a register. And so that conformity with the law of the place where the register is maintained may be decisive in resolving any question of transfer or of competing transfers of rights. And so as the judge rightly points out in my submission of paragraph 48, That's about the law governing the question of whether a purported assignment of an intangible has been effective, and if so, on what date. So, for example,
why is that limited to that?
Well, my lord, it may be that that we need to actually turn up Dicey itself. Perhaps that's easier rather than just going through these paragraphs. But taking a step back, as I pointed out in my introductory comments, it is quite commonplace to have assignments of intellectual property or licenses or whatever which cover intellectual property rights worldwide, and they will be subject to usually one law stated in the contract, and so, for example, might be subject to Italian law. The question is of whether the assignment has been effective, and questions of interpretation of the assignment and so on will clearly still be subject to Italian law, even if the trademark itself that's being assigned is a UK trademark. But equally clearly, there will be aspects of UK law, for example, the fact that an assignment of a trademark has to be in writing, or the question of whether goodwill, the right itself, is assignable, that are tied up with the right itself.
Good. Take Mr. St Quintin's land example. Suppose you've got a multinational retailer, Gap or something like that, have a dispute with somebody else, and they enter into a worldwide settlement agreement dealing with all their stores right around the world, and there's an arbitration provision governed by Californian law. But they dispose of one of their stores in the UK with a registered title. Wouldn't you expect to find that the consequences of the acquisition of that registered title are governed by the Land Registration Act and not by the Californian law of arbitration?
Well, some consequences, my lord, and I think perhaps this is where I do need to turn up Dicey, so that we can have a look at it, because Dicey does make a distinction between whether the intangible can be assigned and the formalities and priorities for assignment, which is governed by the proper law of the intangible, and the validity of the assignment itself, which is governed by the law of the assignment. So we're looking at chapter 24 now, and that is in tab 8 of the authorities bundle.
Yeah.
I've got it, sorry, I've got the wrong bundle. I've got it at tab D, but for those that don't have separate tabs, then it's probably page... well, it's the page that starts with the rule
294, 295.
I'm great. Well, 295. Yes, that's right. 294, assignment of intangibles and intangible things, and then the introduction, which explains, as I think the judge has already pointed out, at paragraph 2451. That they're not easy to state with certainty, and the principal reason for this is that the category of intangible things covers a very wide spectrum of property and rights, ranging from simple contractual debts, etc., etc. All these may be seen as intangible property, which is substantially contractual in origin, but other intangibles, such as the right to sue a tortfeasor, rights arising under trust, rights in intellectual property, etc., do not have an obviously contractual origin, it says. And then if my lords and my lady could turn over to page 296, there's a sidelined passage, a double sideline towards the end of that. Well, perhaps we can start from the beginning. It makes clear the point that the rule has to cover an unusually wide range of legal situations, and at the end it may even be argued that the category of intangible things, the choice of law rules for the assignment of which were developed and refined by Dr. Morris, in order to state the common law rules of the conflict of laws, is no longer sufficiently coherent for it to be given a uniform choice of law rules. So, big health warning on this rule to start off with. And then, if I could ask my lords and my lady to turn over to page 298, paragraph 2454, and to read that paragraph. That's the paragraph with the double lining next to it.
Sorry, did you? I was reading at the bottom of that page. Sorry, I lost where you wanted me to read.
So it's page 298, paragraph 2454, which has the double sidelining next to it and starts the 11th edition of this work. Does my lord see that?
Yes, I mean, I actually, my eyes just alighted on the passage at the bottom of page 296.
Oh, right.
Yes,
Sorry.
so did I. Difference between proprietary and contractual. 24052.
Yes.
Yeah.
I mean, the point made at the bottom of 296 is really that there is a difference between the right itself, which is created and defined by a particular law, and the question of the assignment of it. And that's a point which is made again at paragraph 24054, which I was pointing to on page 298. So there's the difference between the intrinsic assignability of the thing, which is governed by the proper law of the right or thing assigned, and the intrinsic validity of the particular assignment. And there's a final paragraph as well on this point. Well, actually, sorry, two.
We need to look at 24053, I wonder, where the editors discuss this question. Dominant rule for Rule 1, under which the right was created.
Well, if perhaps my lords and my lady could read up to the end of paragraph 2454.
Yeah. What are we getting out of this?
Well, so what I was getting out of paragraph 24054 is that there's a distinction between the intrinsic assignability of the thing. So, for example, can you assign goodwill under English law? Is that something that's assignable? Can only be assignable in certain circumstances, or can you assign the trademark? And which is governed by the proper law of the right or thing assigned, and the intrinsic validity of the particular assignment, which was governed by the proper law of the particular assignment. So you can't just say, oh, well, this is to do with UK and EU trademarks, therefore UK and EU law applies. And just pausing for a moment there is a slight oddity in my learned friend's submission that EU law applies because he is representing a Dutch company, and he's not saying I don't think that Dutch law applies, but for some reason English law applies.
But there's no suggestion that Californian law was the governing law of any of the assignments.
Well, my lords, there isn't. The only evidence about the assignments is the evidence that they were between US entities. So, in my submission, it's highly improbable that English law applied to any of those assignments. I mean, we can look back, and I in fact I have a note to do that.
But the reason that Mr. St. Quintin says it is English and or EU is because some of the marks are English marks and some of the marks are EU marks. And his point is you look to the place where the marks are registered.
Well,
so there isn't a separate Dutch mark, as I understand it, not an issue at any rate.
no, I mean the reason I was raising was perhaps this is a bit of a red herring, but the reason I was raising Dutch law is because why is it that my learned friend says that English law applies to the assignment of the EU marks? I mean, there's no reason English law should apply to the assignment of the EU marks.
Didn't think he was saying that.
Well, I think he is, because his case, I mean, most of the marks are EU marks. There's one UK mark, and his clients are both Dutch entities. I'm not sure why English law.
I think all he's concerned to show, if he can, is that Californian law is not the law.
Yes. That's what one approach, but
I mean, so I've lost the thread here. I mean, Californian law is the law of the 1997 agreement.
Yes.
But your debate and your reference to these paragraphs was talking about the difference, as I understood it, between questions of relating to the validity of an assignment or something to do with the assignment.
Well, what I was pointing out is that my learned friend says, you don't apply Rule 64. I've got a different answer. It's Rule 135. And he says, Rule 135, terribly straightforward. You've got an intellectual property right that is situated in one place, England, he says, for the EU mark and the UK mark. And therefore I wave my magic wand, and that is the right, that is the law that applies. What he doesn't do is engage with Rule 135, which, as my lords and my lady can see, is incredibly complicated because it seeks to try and make a rule which covers all types of property and intangibles. And even in relation to the points where it does specifically discuss intangibles, what it doesn't say is, oh, well, the law that applies is the law that governs that right. And that's the end of the story. It says, well, actually, you've got to look at different aspects of this. And so, really, the point in my submission is that the learned judge was presented with the question of deciding whether Rule 64 applied or Rule 135 applied. And there are good and logical reasons why Rule 64 applies in my submission, which are those set out by the judge in his judgment and expanded on by me. And there are also good and logical reasons why Rule 135 doesn't apply, or not straightforwardly. And so in my submission, the judge reached the correct conclusion. And so really that was the point I was trying to make, that it's not good enough just to say, oh, well, Rule 135, it's all terribly straightforward now, because we can just look at English law. In a situation where it's clear that the impact of English law is quite limited, even for the UK trademark, let alone the EU trademarks.
But his point is, that, at the danger of repeating, his point is, whatever it is, it's the law which governs the assignment which must be looked to decide whether the effect of the assignment is that the burden of the arbitration agreement passed to the assignee.
Well, in my submission, that is not what my learned friend is saying. He's not saying it's the law of the assignment. He's saying it's the law of the right itself.
Okay, but it's certainly not. It's either the law of the assignment or the law of the right itself. It's not the law of the arbitration agreement, the law of the 1997 agreement.
Well, the reason he wouldn't be saying it's the law of the assignment is because he would have no basis for saying that the assignments are subject to English law. I mean, there's you know, they're all between. I mean, I was going to come on to this, but maybe it's a good idea to do this now. In the judgment, paragraph.
Why does it matter whether they're subject to English law or some other system of law? You're entitled to your stay, as I see it, if and only if you can show that the Californian law applies to the arbitration agreement and thus binds the claimants. If it doesn't, then he's entitled to bring his action.
Well, in my submission, obviously, Californian law applies for...
No, I follow.
Yes.
That's your case. And
yes.
if it doesn't, you lose. It doesn't matter whether it's Dutch law, EU law, English law, or any other system of law, as long as it's not Californian.
Yes, but I am testing how convincing my learned friend's argument is that it's subject to English law by taking my lords and my lady to Rule 135, which is the rule that he relies upon. And you know, as I've already said, obviously I'll come back to HHJ, but in HHJ he points to the fact that people are turning up rules other than Rule 64. But perhaps if I could just finish the point I was going to make just briefly on the facts, so that and my lord and my lady may say, well, that's not relevant, but at least my lords and my lady will be apprised of all the facts because we haven't gone to this yet, at least not in the judgment. The assignments that are relevant, as described in the judgment, are those set out at paragraph 11. I'm looking at the judgment now on page 97. And I'm afraid I am going to come back to Dicey briefly, so it's probably worth keeping that out. But so January 1989, the granted UK mark was assigned to a US entity. And that assignment, it can be seen, is from a US entity, Gregory Lang Inc., to another US entity, BHPC Marketing Inc. As it happens, I think we have got, that's the one assignment I think we may have in the bundles, but I don't have a reference to it, but it doesn't say what the applicable law is. And then later on at paragraphs 15 and 16, you can see the other assignments. So BHPC Marketing assigned the UK trademark and the 3 EU marks to BHPC Associates LLC, another US entity. And then those 4 marks were assigned by Associates LLC to International LLC, so that's another US entity. And then the UK mark was assigned by International LLC to the first claimant, so it went from a US entity to the Dutch entity. And in fact, the judge says at paragraph 16, just for completeness, I was shown a written recording of one of the assignments I've referred to, but not the others. It's not clear which law governed each of those assignments, but they played little part in the arguments. It was not in dispute that all the assignments were effective.
Yeah.
I mean, if there was a series of assignments, as you've just shown us, under different governing laws, but because of the different parties, that I suppose would suggest that and that was possible. That might support to some extent the proposition that the effect of assignment might be better governed by the law of the thing.
Yes, although in my submission that's not supported by Dicey, because we've already looked at paragraph 2454, and I was also going to take my lords and my lady to paragraph 2469, which is on page 304. Which also talks about the distinction between whether the assignability of the right itself, which must inevitably be governed by the law under which the intellectual property right was itself created. I'm reading from the very end of the paragraph now on page 305. And the law which governs the contract of assignment.
Is paragraph 24070 also of some relevance? The more complex assignments that you're talking about. The identification of the correct approach when a creditor purports to assign debts presently owed to him or receivable by him at a future date. Questions whether the assignee obtains a good title to each and all of the debts assigned. Application of clause 1 of the law would suggest that this may be determined only by an examination of the law under which each separate debt is assigned. Is that your point, that it's sensible to have one law governing all?
Yes, indeed, and I mean, I'm not sure this paragraph is directly in point, because I think that this is a section of the book which is dealing with different types of assignments, and intellectual property right assignment is specifically 24 and dealt with in the previous paragraph. But I absolutely agree with the general point being made here, and in my submission it assists my case, which is that when you assign worldwide rights or license worldwide intellectual property rights, you do it subject to one law usually, and it would be deeply commercially inconvenient if it were decided that because you're assigning rights from different places in the world, in fact, on the conflict of laws provisions, the law that applies is the law relating to each, or the law of the country in which each of those rights subsists, as opposed to the law of the contract itself that the parties have chosen.
But the chosen law in the contract of assignment, is that what you're talking about? You keep talking about the law of the contract. I mean, trying to remember your contract, the 1997, is not a contract of assignment.
No, it's a coexistence agreement.
Yes, I know. So,
yes.
But when you're making the submissions, what contract are you talking about in which the parties have, in a normal case of an assignment of an intellectual property right, the contract is the contract of assignment?
Well, or it might be a license agreement or a coexistence agreement. I mean, all of these agreements often deal with worldwide rights. They don't have to be assignments. They could be licenses or coexistence agreements. And one would expect that they would only be subject to the single law that the parties have chosen, not the law of all the different countries in the world where the rights subsist.
Right.
Because, I mean, again, stepping back, at the end of the day, the question is it appropriate for there to be an arbitration in this case? Because that was decided upon in the 1997 agreement by parties who wanted to be governed by California law and wanted their disputes to go to arbitration. And in my submission, it certainly makes commercial common sense, and in my submission it's also consistent with the legal test that we've been looking at, that the court should decide that by reference to California law. Not by reference to the particular law relating to one of the many rights, which, as I say, included Japanese rights, that were discussed in that agreement. And yes, it's right that the claimants were not party to that agreement, but nevertheless, that there is the clause 12 point, and we will come on obviously to see what the California law position is in relation to that.
But can that choice of law override a domestic legal system which, for example, by statute has a different regime? So that, for example, if a particular country says, well, we want a perfect registration system which you don't have to inquire other than on the register. In other words, the register is a perfect mirror of both what is being transferred and any burdens which affect that thing. Are you saying that because the parties to a pre-existing agreement have chosen a different system of law in their contract, that would override the system of law that the legislature in a particular country had enacted which was to the contrary effect?
Well, I mean, it's always hard to sort of deal with analogies, which in my submission are different. But the point here is the question is whether this should go to arbitration in California, and that is a question about the arbitration agreement. The question is not, has this assignment or agreement been validly registered in the UK? I mean, my learned friend has a point that this type of coexistence agreement, he says, has to be registered in the UK and indeed in the EU. But we say that that's a bad point in any event. But it doesn't arise because we're dealing with the question of whether the agreement whether the dispute should go to arbitration. So that is the point. Which court or which tribunal should decide
Why
the
does that
issue?
make all the difference?
Because the rights in arbitration arise from the agreement between the parties. And the arbitration agreement, as I think is cited somewhere by the judge in his judgment, is a separable agreement which continues regardless of the validity or otherwise of other parts of the agreement. I mean, that's I think he says that that's part of the alphabet of arbitration law.
I mean, just following up from the points my lord was putting to you, there are a number of different kinds of registration system in this country which say that if a particular agreement is not registered, it's void as against a purchaser of whatever it is, the property against which it should have been registered. So do you say that if such an agreement had contained an arbitration clause governed by Californian law, that the arbitration clause would still be effective because it's a separate agreement from what should have been registered, and the fact that English law says, well, the agreement's void as against the purchaser, is overridden by the party's choice?
Yes, I would say that based on the fact that the arbitration agreement is separable. And I mean, I think that is in the judgment somewhere, and it's certainly cited in...
Yes.
But it's only separable because the parties say it is.
Yes, it's separable because the parties say it is, but the point is who is a party to the arbitration agreement and its scope, interpretation, etc. All the questions about whether the arbitration agreement is binding are governed by the law of the arbitration agreement. So, my lord, I've just, and my lady, I'm just checking where I am in my note. So I think, let me just check in relation to Dicey that we've done all the relevant paragraphs that I wanted to turn up. Yes, I've covered that. So what I wanted to, and I've also covered the point about the assignments in the judgment. And so what I wanted to go on to was to consider the points that my learned friend makes in his skeleton argument, and of course those points that he's made this morning. And the first point, which I've touched upon, I think already, is what he refers to in his skeleton argument as the circular logic point. And I think this morning he said that there was a prior point to decide. And essentially my answer to this, which I've already given, is that if that point was right, then it would also apply to the question of who was a party to the agreement, for example, because it could be said in relation to that, well, you can't even consider whether someone's a party to the agreement under the law of the agreement because you don't even know that they're a party. So his circular logic point and his prior question point in my submission would apply equally to the question of who is a party to the arbitration agreement, which is very clear are to be decided under the law of the arbitration agreement. I mean, the point is, my lords and my lady, you've got to start somewhere. And you've either got here the law of the arbitration agreement, or my learned friend says you can bring in the law of these separate rights which have been assigned, and that's where you should be starting. And in my submission, that's just not consistent with the clear case law and the clear statement of the rule in Dicey that you start with the law of the arbitration agreement. Now, I'm going to come briefly to Peterson Farms and Edgezarian. And in my submission, whilst the facts of Edgezarian and these submissions are a little bit complicated, what that does and Peterson Farms does is simply support the point that if you're looking at the question of who is a party to the agreement, then you're looking at that under the law of the arbitration agreement. And so I'll start briefly with Peterson Farms, which is in the authorities bundle of tab 6.
Do you mean who is a party, or do you mean who is bound by?
Well, these are talking about who is a party. I'm not sure, my lord, that there's a difference between who is a party and who is bound by.
Well, there was at the start in this case. I mean, and to where we are now. I mean, at the start, it's clear that the claimant was not a party.
Yeah.
We've
Yes, that's right. Yes.
We've got the first point of the judge's decision that it had become a party, which is a separate
Yes, and I'm going to
issue.
come on to that later. Yes, but assuming they're not. Yes.
Assuming they're not,
Yes.
then the question is not, are they a party? The question is, are they bound? And are they bound as a result of the assignment?
And clause 12 of the arbitration agreement.
Yes, so that's the two limbs
Yes,
we keep coming
yes,
back to.
yes,
If you didn't
indeed.
have clause 12, you wouldn't get to the second limb.
Yes.
But clause 12 doesn't do it for you on its own.
Yes, I suppose that must be right, because I have to show that I'm an assign, or sorry, that they're assign, that they're assigns.
Yeah,
But really the reason for going to as I say, for going to Peterson Farms and Edgezarian is to just show that the issue of who is a party is definitely decided. And I appreciate my lord is saying, well, that's a different question. But in my submission, it certainly does shed light on what law would apply to the question of who is bound. Because if as I say, Dicey is right, that the scope interpretation, who is a party, and there was one other that I've now forgotten, scope interpretation, Rule 64.
validity, scope,
Validity,
interpretation.
exactly. If all those things are to be decided under the law of the arbitration agreement, then one would expect that the question of whether or not you're bound is also decided under the law of the arbitration agreement. I mean, there's no logical reason for deciding that under a different law.
Well, it depends on what it is said that makes you bound, whether it's your membership of a corporate group, or whether it's because of an assignment, or whether it's because of some other thing or event. I think that's the question, isn't it?
Yes, although logically, even to look at that question, you have to start thinking about the law that you're going to apply, because what I want to answer to my lord's question is, yes, but look at the expert, the law of the California, the evidence of the Californian lawyer. He says, look at the agreement, clause 12, look at the, it is circular in a sense, whatever way you look at it. Anyway, I'll try and do this relatively quickly, because I'm not sure I get a massive amount from these authorities. But Peterson, basically, the part of Peterson that I'd like my lords and my lady to look at is 146. Well, actually, it's probably better to quickly look at the head note. There was a contract for the sale of live poultry. This is on page 138, tab 6. The claimant Indian company was the purchaser, incorporated, and the defendant was a company incorporated under the laws of the state of Arkansas. As the seller, the applicable law was that of Arkansas, and then the question, second paragraph, the claimant initiated arbitration proceedings, and one of the issues concerned whether it had jurisdiction to consider and determine the damage claims of other entities within the claimant's group who were not named as parties to the agreement. And so then, again, looking at the head note, bottom of the page, the application would be allowed. And it's right at the last sentence on that page, the identification of the parties was a question of substantive, not procedural law, and thus in the instant case was governed by Arkansas law. And then the reasoning is at paragraph 43, and really it's only necessary to read the sideline part of paragraph 43, paragraphs 44 and 45, which are over the page.
System of law were the arbitrators purporting to apply in applying this group of companies doctrine? Where does that come from? Another decision of the ICC?
I think they were purporting to apply English law, but I could be wrong.
Well, English law doesn't have a group of companies doctrine.
Oh yes, that's a bit of a...
So what Mr. Justice Langley decides is that the contract, including the arbitration agreement, is determined by Arkansas law, that the identification of the parties is a question of substantive law, in that case Arkansas law, because Arkansas law governed the contract.
Yes.
Therefore, in order to find out who is entitled to sue under the contract, or whose claims are encompassed within the contract, you had to apply Arkansas law.
Yes. Yes.
Yeah. So you would say the law of the contract, in the present case, is Californian law.
Yes.
Treating the identification of who is bound by it as a question of substantive rather than procedural law, you still apply Californian law. That's what the judge did.
Yes.
And he was right to do that.
Yes. Exactly. And then we better have a look at Edgiazarian as well. That's at tab 3. And I won't go through, my learned friend's already gone through the head note. And so it's really just a question of pointing out some particular paragraphs starting on page 75, which I say support the established position that I put forward, that the law of the arbitration agreement governs who is party to it.
Sorry,
And
sorry, can I just go back a second? In that exchange, and looking at the bottom of page 147, I mean, Mr. Justice Langley was just dealing with the question of who's a party.
yes.
And I don't think there's any, as I understood it, that there wasn't any actual dispute that if the question is asked who is the party to the agreement, in the instant case, our case, one applies the law of the agreement, of the 1997 agreement, if you're trying to answer the question who is a party.
Agreed.
But that's as far as this case goes.
Yes, and so I think I hope I prefaced my submissions on these authorities by saying I don't make the submission that these give the answer,
No.
as in that they're directly in point, but I do pray them in aid really for the following reason, which is, well, I suppose for two reasons. One, because they show that all those points in Dicey, plus the question of who is a party, are decided by reference to the substantive law, the law of the arbitration agreement. And so it would seem to follow from that, or it follows from that in my submission, that the question of who is bound should also be decided by the law of the arbitration agreement. And I do point to that passage in Professor Briggs' book, which uses the word binding. And the other point is, I say that this is an answer to my learned friend's circular logic or prior question point, because I say exactly the same point could be made about the question of who is a party to the agreement. Because it would be said, well, how can you say that California law applies to whether or not they're a party? Because you're already deciding it by applying that law. Do you see what I mean? Which is why I say that my learned friend's circular logic point doesn't actually have any force. And so the parts that I wanted to point to in the Edgiazarian decision were simply those where it was accepted by both counsel that the well-established authority that English law governs who is a party to the arbitration agreement, and the reasoning connected with that. So we've got, first of all...
Do you accept that Edgiazarian is right?
Do I accept that it's right?
Yeah.
Yes. I mean, I'm not trying to say that there's that the reasoning is incorrect. I mean, on the basis of the particular Russian law point and the particular position of that party.
Right. Yes.
And in fact, once I've gone through the particular points I wanted to draw attention to, it probably is relevant to consider the specific examples given in Edgiazarian as to where different law applies, because in my submission they are not on all fours with the case here. So I was going to point to paragraph 14.1, and the established authority that English law governs who is a party, and the final sentence, nevertheless, the underlying concept of consensus requires the proper law of the contract to govern who has agreed to it. Then there's the reference to Peterson Farms, which I don't need to go to because we've already seen that. And then, perhaps more importantly, in paragraph 17, Mr. Smuhar's answers to Mr. Millett's submissions. First of all, he accepts the proposition that English law and substantive law, not procedural law, govern the question as to who is a party to the arbitration agreement. And then he makes the additional point that at English law there will be many occasions when parties who are not signatories to an arbitration agreement are entitled or bound to be parties to the arbitration. And then he lists some examples: agency, lifting the corporate veil, assignment, and other scenarios such as universal succession or merger, which may be applicable to other systems of law. And then he refers to the fact that the applicable law, this is the end of paragraph 17, doesn't simply mean the proper law of the agreement. And then I think he continues with some additional examples there. But in my submission, none of those examples are at all on all fours with the intellectual property
but you skipped
situation.
You skipped over the bit in the middle, just between E and F, where he says this case isn't about who's a party. where the question to be properly characterised is not who is or was a party to the arbitration agreement, but whether there is jurisdiction over a non-signatory to the arbitration agreement, then English conflicts rules will or may address another system of law. In other words, he's saying, the law of the arbitration agreement isn't the last word to be all and the end all. Where you're asking the question, not who is a party, but who is bound.
Well, I don't think he's saying specifically who is bound, but I would also draw attention to the fact he was saying that they may, in certain circumstances, address another.
I think that whether there is jurisdiction over a non-signatory is synonymous with whether somebody is bound to be a party to the arbitration. I mean, just as he says between D and D, he's using the two phrases interchangeably, isn't he?
But all of the situations that he's talking about here are to do with specifically the legal personality. So they are situations such as where you've got groups of companies or you've got a state-owned entity with separate legal personality.
True, but the point he's making is that you don't answer all those various questions, i.e. who's bound to be a party to the arbitration or whether the arbitrator has jurisdiction over a non-signatory. You don't just answer those questions by reference to the governing law of the arbitration agreement.
Well, in my submission, that in the right circumstances, there may be an additional legal, there may be an additional relevant law that applies.
That's really your point, isn't it? You first of all ask yourself, as a matter of the law of the arbitration agreement, is X bound by the arbitration agreement? If answer yes, then the arbitrator has jurisdiction over X. If answer no, then you may go outside the law of the arbitration agreement and you ask yourself, well, is there some other system of law, relevant, applicable system of law, which would make X bound by any award or join in the arbitration? So that what the judge is deciding, you say, is an enlarging jurisdiction.
Yes, exactly. It's an additional step that you can take to say that you're bound, rather than saying we ignore the fact that you're bound under the law of the arbitration agreement. And in my submission,
and that's why you get at the bottom of paragraph 17 that both counsel, Mr. Smuher rather, says that the applicable law does not simply mean the proper law of the arbitration. There may be some other law as well.
Yes, indeed, and also the reference to will or may address another system of law.
Right. Well, you'll obviously deal with the Ruritane example because that seems to be one of Mr. Quintin's best points.
Well, my Lord, I wasn't planning to look at this, but I'm obviously, if my Lord thinks it's one of the best points.
Well, speak for myself, as we say.
I mean, as I've already said, I think one of the difficulties with these analogies is they're never quite perfect. And they certainly aren't. I mean, this one it is all about company law, for example, and it is not about intellectual property rights. So I would certainly start by drawing that distinction. So, I mean, I'm not sure I can say anything more than that, than just, and again, it's considering the particular...
Well, you may say that the Ruritanian law in the example is not the Ruritanian law of contract, it's the Ruritanian law of companies.
Well, yes, indeed, it relates to the position of the party rather than the contractual position. So, my lord, I think I've now addressed all the points I wanted to on the submissions that my learned friend made this morning. I was planning to address some of the submissions from my learned friend's skeleton argument, but I think things have moved on somewhat. So it probably makes sense now to move to the point about assuming California law applies, the judge's decision on Californian law, unless my lords or my lady have any further questions on...
It's just while we were with Ruritanian law, I think there was another, I don't know, are you going to address the Ruritanian trespasser?
Oh, the Ruritanian trespasser. My lord, was that my...
That was Mr. St. Quentin's follow-up to Ruritanian law, i.e. the person who, when accused of trespass in the UK, says yes, but there's a Ruritanian contract which says I have a license to occupy this land in July.
My lord, I didn't, to be perfectly frank, I didn't fully understand my learned friend's example, but one thing I did or do want to say about my learned friend's example is that in my submission, my learned friend was confusing the substantive dispute about trademark infringement and any defences we might be entitled to rely on in relation to trademark infringement, and the question that we're looking at here, which is whether the arbitration agreement, whether there has been an arbitration agreement and whether this is a dispute that should go to arbitration. So in my submission, what he seemed to be saying is, well, the trespasser shouldn't be allowed to rely on certain substantive defences, as opposed to saying the arbitration agreement shouldn't apply for some reason.
He also said his contract contained an arbitration clause requiring the question to be determined in arbitration in Ruritania.
So my lord, let me see if I can restate it. His proposition is that we're not talking about intellectual property, we're talking about a piece of land, which is registered in England. It's registered in England.
Yeah, and the English land registrations says that if you don't register certain burdens on the land, then a purchaser takes free. And nothing is registered. A trespasser comes onto the land after the purchaser has bought. Purchaser says to trespasser, "Get off my land." He says, "But I have this agreement with a previous owner of the land governed by Ruritanian law that says I have a right to be here, and any dispute has to be arbitrated in Ruritania."
Yes, so
I think that's the fact.
I think that was quite similar to the point that my Lord Justice Lewison raised earlier, and I said that the arbitration agreement is separable. Point one, and so yes, I would say you do have to you have to go to arbitration in Ruritania, and secondly, it also makes an assumption which I do not accept, which is that you do have to register a coexistence agreement under English law. So my learned friend has a point which was decided against him at first instance, which he hasn't addressed in his oral submissions, which is that you have to register a coexistence agreement. And the judge decided that point was wrong. And so in my submission, that the analogy is not a good one because it doesn't arise on the facts of this case.
No, your point is because it's an arbitration clause, arbitration agreement.
Yes.
It overrides any requirement for registration of the agreement of which it forms a part.
Yes, and that's because the arbitration agreement is separable, and that was a point that was addressed by the learned judge in his judgment. And I think it may be addressed also, let me just remind myself, in
Well, the Act says so.
my skeleton argument somewhere.
The Act itself says so.
The Act itself says what?
That it's a separate agreement.
Yes. So the judge addresses
Section
it.
7.
Yes, and the judge addresses it at paragraphs 59 to 63.
But you don't need to go that far. You don't need to say that the arbitration agreement overrides a registration system if, as you say, the coexistence agreement was not an agreement that was required to be registered in order to bind an assignee of the trademark.
Yes.
That, you say, is what the judge decided, and it's not the subject of the appeal.
Yes, I mean, so he decided it between paragraphs 59
Yeah.
and 64, and I have addressed it in an annex to my skeleton, but I don't understand my learned friend to take the point today, and I'm pretty certain it's not in his, well, it may or may not be in his grounds of appeal. Let me just check that point so I don't say anything wrong.
Paragraph 58 of the judgment.
Paragraph 58 of the judgment, yes, that's right.
Can I just ask
Yes.
about the annex to your skeleton?
Yes.
Where will I find that?
I hope it's at the end of my skeleton in the bundle. So that should be at tab 3 of the core bundle. And it should be pages 63 and 64.
Yes, I have that. Sorry, I was thinking supplemental rather than annex.
Yes,
Forgive me.
yes. And so I just set out there the fact that the judge rejected the argument on 2 grounds, because the 1997 agreement's not a licence, but it's a coexistence agreement, and because the arbitration agreement had to be regarded as distinct and remained unaffected. And I pointed out that on appeal, the claimants had said the judge was wrong on these points, but hadn't provided any reasoning. But they've taken a different point in their skeleton, or my learned friend has taken a different point, which is that they're bona fide purchases for value without notice. And I say that point doesn't arise where you've got a statutory scheme of registration. And just because I don't want the appeal to go forward on an incorrect basis, I think the position now under Brexit is that all these EU marks have been translated or have been become comparable UK marks, actually. And so my point about the EU regulation, which I make right at the end, may not be a good point post-Brexit, but in my submission that doesn't matter, because the point I make at paragraph 4 of the annex is still a good one, which is that where you've got a statutory scheme, then that's what you look at. And the statutory scheme only requires registration of, I think, licenses, assignments and securities, and this coexistence agreement doesn't fall within the scope of that. So
I think we better move on.
Yes, I think I'm conscious
time.
of time now. I expect my learned friend will want me to leave a little bit of time for
Yes,
him
he will.
to reply. So that the next point is, assuming California law applies, then did the judge come to the correct decision on the evidence of California law? And as my lord said this morning, that is a high threshold for my learned friend to show on appeal that the judge was wrong. And in my submission, the judge's approach to California law is unimpeachable. He looked at California law in a long passage of his judgment, or at least the main point of California law, between paragraph 65 and 96 of the judgment. And he did so in my submission very carefully. I'm just going to sort of skip through the judgment and give some headlines as to how the judge approached California law. He first of all, and this is page 115 of the bundle, core bundle in the judgment, he first of all identified the two experts and their experience. He then summarised Mr. Lewelyn's evidence. He was my expert, and he, in a series of propositions, set out at paragraph 69 to 72, and the key propositions that I understand to be challenged are really the ones at 71 and, well, 71 I think is perhaps the crucial part, or 70 and 71. And then he summarised at 73, applying the principles. Mr. Lewelyn states his opinion that the effect of the 1997 agreement under California law is that the agreement as a whole binds the claimants as assignees of the trademarks. And so accordingly, the claimants are bound by the arbitration provision. He then summarises Mr. Sosnicki's evidence in response, and he points out that Mr. Sosnicki accepted that under California law, an obligation may pass with an asset as a burden attached to the asset, such that it becomes an obligation of the assignee of the asset. And then he had two qualifications to that. And his complaint, or his two complaints, were first that Mr. Lewelyn had not.
So
there's a not missing there.
I was going to say in 74 there's a not missing.
Yes, there is. Had not analysed why California or federal law applies to the question of whether a burden can attach to a non-US trademark, and that if it can, Mr. Lewelyn hasn't shown that the burden can be an obligation to arbitrate, and he takes Mr. Sosnicki's two, as it were, complaints about Mr. Lewelyn's evidence and looks at them separately, and he sets out Mr. Sosnicki's evidence first in detail, and essentially that's the whole of his evidence on the point. And then he sets out Mr. Lewelyn's response.
The curious thing about Mr. Sosnicki, he doesn't say that Mr. Lewelyn is wrong, he just says he hasn't explained this and that.
Well, exactly. And so in my submission, certainly Mr. Sosnicki's evidence was rather weak overall. And really my learned friend's complaint amounts to saying, well, Mr. Lewelyn couldn't point to an authority that was exactly on point, or an article that was exactly on point. But as we all know, in the law, there isn't always a case completely on point. And the question is whether the reasoning stands up.
That's why you have experts.
Yes, indeed. And the reasoning that Mr. Lewelyn gave in my submission was unimpeachable, because he basically said, well, there is evidence that burdens can pass with the trademark, and there is also evidence that you can be party to an arbitration agreement without knowing about the arbitration clause. And so he sort of put those two things together in addition to clause 12. But I'm paraphrasing somewhat. You can see that the judge set out Mr. Sosnicki's evidence, then Mr. Lewelyn's response, and in particular, as we've already seen at paragraph 10, he said that California law applies to the dispute in question as a matter of contract, and he said that was a question of construction. And then he also pointed out at paragraph 13 the point about the assignee of the trademark steps into the shoes of the assignor. And in fact, one of the difficulties when you're looking at the judgment is that the paragraph or the parts of Mr. Lewelyn's evidence that the judge has cited here end at paragraph 15, and it's actually quite helpful to look over to later in the judgment at paragraph 86, which is on page 125. Confusingly, there are two paragraph 86s, to just see the rest of Mr. Lewelyn's reasoning, which flows. So he has cited the whole thing, it's split up in two places. And so you've got the rest of the reasoning here on page 125 of Mr. Lewelyn, that arbitration clauses are frequently applied. I'm reading from his paragraph 19. are frequently applied to entities such as assignees and third-party beneficiaries that did not sign the contract containing the arbitration clause in question. And he also relies on paragraph 21 on the fact that the 1997 agreement provides that it shall be binding on and inure to, among other categories, assigns. Furthermore, assigns are also entitled to enforce the provisions of the 1997 agreement. Thus, as assigns, claimants were both intended to be bound by and have the ability to enforce the 1997 agreement. Accordingly, the arbitration provision is a burden that flows to the claimants as third-party beneficiaries of the 1997 agreement.
But is he talking here about an assignee of the contract containing the arbitration provision all the way through this?
Well, in my submission, he is talking here always about the facts in this case, and that is the fact that they were assignees of the trademark.
But, I mean, for example, but paragraph 19 that you just took us to, sorry, paragraph 86, subparagraph, the quote from paragraph 19, yet
Yes.
Mr. Sosnicki ignores
Yes.
that under California law, arbitration clauses are frequently applied to entities such as assignees and third-party beneficiaries that did not sign the contract containing the arbitration clause in question. I mean, he's talking there about if there's an arbitration clause in a contract between A and B,
Yes.
and B assigns the benefit of the contract to C, is C bound? And the answer is yes, he's bound as assignee.
Yes, and as I've said already, that there wasn't an authority that said if you're under California law, if you're the assignee of a trademark subject to a coexistence agreement and it contains an arbitration clause, you're bound by the arbitration clause. So what Mr. Lewison did was examine two lines of authority. The first, that trademarks, when assigned, are subject to the burdens or any burdens upon them, and also the fact that under an arbitration agreement, under an assignment of a contract, that could be binding on assignees. So absolutely accept that there wasn't an authority directly in point, but his reasoning in my submission was correct in saying that there was a general rule, or two general rules, and he put them together and said that means that under Californian law.
But then I can't understand what paragraph 21 means, page 126. He says the 1997 agreement provides that it shall be binding and inure on, amongst other categories, assigns. Yeah?
Yes.
That means assigns of the 1997 agreement.
Well, I think it goes. In my submission, it goes further than that, because it was clear from the.
But then he goes on. Furthermore, assigns are also entitled to enforce the provisions of the 1997 agreement, and he quotes there. That's a reference just to the wording of the agreement, I think. He then says, thus, as assigns, claimants were both intended to be bound by and have the ability to enforce the 1997 agreement. But the claimants weren't assigns of the 1997 agreement.
Sorry, I've slightly lost where my note is reading from.
I'm reading at page 126
Yes.
of the bundle, paragraph 21, the quote.
Yes.
And I'm just following up on this point that we've got to be careful about which agreement is said to have been assigned here. Because he says the 1997 agreement provides it shall be binding and inure on, amongst other categories, assigns.
Yes.
And assigns are also entitled to enforce the provisions of the 1997 agreement. Now, those are references to particular clauses.
Yes.
Clause 12.
Yes.
Right? He says, thus, as assigns, claimants were both intended to be bound by and have the ability to enforce the 1997 agreement. But I'm just making the point, the claimants weren't assignees of the 1997 agreement.
No, but in my submission, he was reading the term assigns more broadly to cover assignees of the trademarks.
Well, if you go back to Mr. Llewellyn's first statement, supplementary bundle, tab 7, para 97.
Page 97 is there.
Page 97,
Yep.
para 28. He starts off by saying that issues relating to the marks will be governed by the Lanham Act. California court apply federal law. And then he says that an assignee, and here he must mean an assignee of the marks,
Yes.
take subject to the burdens. Then he says burdens include the terms of any agreements. And then he says, well, that includes coexistence agreements. And that knowledge doesn't apply.
Yes.
Then in his second statement, he comes back from the Lanham Act, as the judge says, he raised back from that. This is tab 9, page 135. 11, para 11, he says, the question is how California law will be applied to dispute the claimants, assignees of the marks on the one hand, and the respondents on the other. And that's his starting point. So I think he does understand that they're only assignees of the marks. He goes on to say that again at paragraph 13. And then he says the fact in 14, the fact that the marks aren't US marks doesn't make any difference.
Yes, indeed. And he is pointing in various places, I think, to the very broad wording of the agreement. First of all, the fact that it covers marks worldwide and was clearly intended to govern the parties worldwide, which we've seen from the clauses we've looked at, and the fact that it's clear from clause 12, which is itself extremely wide, that the intention of the parties was it was going to bind and inure upon pretty much everyone they could list that they could possibly think of. I mean, it's an incredibly wide clause. Successors, assigns, licensees, distributors, wholesalers, customers, subcontractors, and others working under the the license of a party, etc. And as has been pointed out, it's not as though Mr. Sosnicki came back and said that's not right. What he said was much more half-hearted than that. Sorry, I've got a reference in my notes somewhere. It's on page 124 of the judgment, at paragraph 27 of Mr. Sosnicki's statement, where he says that
he might have considered.
He might have considered, and then of course he does go on to consider whether an obligation to arbitrate is something. I mean that's what he's addressing in his response.
Now I'm going to have to stop you in about 20 minutes, Miss Lane.
I shall bear that in mind, my lord. So in my submission, it's a lengthy and careful judgment on the points of California law, and the conclusion is really paragraphs 93 to 96, which is, first of all, that he accepts Mr. Llewellyn's evidence that these two cases establish the general proposition that a burden attaching to a trademark, which is the subject of a settlement or coexistence agreement, passes with the assignment, and it makes no difference whether or not the assignee knows about the burden. The judge is clearly cognizant of the fact that in Russell Road and Mag Instruments the burden wasn't an obligation to arbitrate. He does say, and my learned friend complains about this, that it was incumbent on Mr. Sosnicki to explain why such an obligation would be an exception to the general rule, particularly when he didn't cite any authority which states as much. He provided no such explanation. Well, my learned friend points to the evidence of Mr. Sosnicki about arbitration agreements and there needing to be a clear agreement between the parties. But it's absolutely plain that, having cited that, the learned judge knew that was what the position that Mr. Sosnicki was taking, and that he rejected that. Because, as he said at paragraph 95, on balance, he preferred Mr. Llewellyn's evidence. And in my submission, looked at as a whole, that there is nothing to complain about, at least not to the standard needed on an appeal of this kind, in the way that the judge approached the evidence of California law. Now I'm just going to check that I haven't missed any points in my skeleton argument that I wanted to make on this, but I think I have made all the key ones. I mean, again, I had some specific points relating to the way that my learned friend put things in his skeleton argument, but I think really I've covered the important points, and the main point being that there was nothing in it. It was a decision which was perfectly reasonable for the judge to reach on the basis of the evidence before him. That is Mr. Lewelyn's clear and convincing evidence, both in chief and in reply, as to what the position was, and Mr. Sosnicki's rather weaker evidence, which didn't clearly challenge the points that Mr. Lewelyn was making.
Yes.
So unless my lords or my lady has any further points on that, then I was going to go on to this, what I'm calling the secondary route. And my secondary route, that what we've just addressed is my primary route in the appeal, which is California law applies, and the claimants are bound under California law by reference to the parts of the evidence we've just discussed. There was a secondary route which also relies on California law applying, but rather than relying on the parts of the evidence we've just looked at, it relies on the evidence relating to estoppel. And so the position in relation to estoppel is that, as my learned friend, I think, has pointed out, his clients relied on the 1997 agreement in the Mexican Trademark Office. And in the judgment at paragraphs 34 to 42, the judge sets out the facts relating to that. And essentially, starting on page 107 at paragraph 34, the claimant's parent company wrote on behalf of the first claimant and said that he'd been advised that there'd been a previous arrangement in place, and so asked for a copy of the past agreement, and that led, as you can see at paragraph 35, to a copy of the 1997 agreement being provided to the claimants. And then the claimants wanted, as my learned friend has explained, to make an application to the Mexican Trademark Office, where they needed to show the Mexican Trademark Office that they benefited from the coexistence agreement, the 1997 agreement. And so they sent an email asking, and that's the email set out at paragraph 36, for the defendants to sign the consent letter for Mexico in accordance with the coexistence agreement. And so the defendants provided a letter of consent, and that was had the text that my lords and my lady can see set out at paragraph 37, and also, and this is important, the text set out at paragraph 41.
Yeah.
And the reason the text at paragraph 41 is important is because reliance is placed by the claimants on the fact that the defendants added the words which are underlined at paragraph 37. SBPC are parties to a worldwide coexistence dated October the 6th, 1997, and pursuant to that agreement, SBPC consents to this registration. And that is correct. They did add it, but it said, oh, well, we, the claimants, didn't have time to get rid of that because we had to get this off to the Mexican Trademark Office quickly. And they say, therefore, that that's a factor in their favour. But in my submission, that's really irrelevant because the letter already contained the words which were not added by the defendants, but which the claimants themselves had drafted, saying, attached to this letter is the coexistence agreement executed between SBPC and Lifestyle Equities CV.
That's plainly wrong, isn't it? I mean, the one thing that Lifestyle Equities CV didn't do was to execute the coexistence agreement.
That's correct, but they obviously wanted to rely on the existence of the coexistence agreement in the Mexican Trademark Office.
True, but they said here's the coexistence agreement. They just misdescribed it, didn't they? I mean, it's quite clear when you look at it. It's not quotes executed between SBC and Lifestyle Equities.
Yes, I mean, but bearing in mind that this is essentially. Well, I think the important point is it doesn't really matter whether it's inaccurate. They wanted to take advantage of the coexistence agreement. And
why would they have needed your client's consent to take advantage of the agreement? If they were bound by the agreement or stopped from contending that they weren't, surely all they would have to do is to produce to the Mexican Trademark Office the agreement. Say, we're assignees of this agreement. We don't need consent. We've got consent. It's in the agreement.
I mean, my lords, I'm not sure the evidence reveals why it might have been necessary for the Mexican Trademark Office to have my client's consent, but it may be that the rule provides.
But surely the point is that the claimants were not content simply to rely on the coexistence agreement, which on its face consents to the use of the various marks all over the place, all around the world. They wanted something more from your client, namely a consent, which they asked for and got. If they were to be in the same position as they would have been had they been original parties to the coexistence agreement, they wouldn't have needed that consent. They'd have just shown it to the Mexican Trademark Office.
Well,
and the correspondence begins, as the judge quotes at paragraph 34, by saying that we don't want to fight about all this or litigate about this. Give us a copy of the agreement. We don't surrender any future rights we may have to pursue all available means to pursue our rights to our HPC trademark. So they're not saying, oh, of course we agree to be bound by all this. They're saying quite the contrary.
Well, my lord, at this stage, all I'm doing is relying on the fact that they took the benefit of the agreement.
Well, that's what I'm questioning. Yes. They took the benefit of a consent, which the agreement did not require. It was outside the terms of the agreement.
Well, my lord, what they said is that they asked for a signature of the letter of consent in accordance with the coexistence agreement. In other words, they were saying you are obliged under the coexistence agreement, this is at paragraph 36, to sign the consent letter because, I'm not sure we looked at this part of the agreement, but the agreement itself, I think, states that it states that they may register the marks in any countries in the world, and agrees not to interfere with or oppose such registration, and specifically consents. But I mean,
it doesn't require any further consent. It's in the agreement.
Well, my lord, that may be the case, but it may simply be that under Mexican law and the rules of the Trademark Office, you've got to have the signatory of the owner of a prior right. I mean, that is sometimes the position that you have to have a signature from the owner of the prior right. May or may not be so,
but it's up to you to show there's an estoppel, isn't it?
Well, my lord, it is up to me to show there's an estoppel under California law, and so we rely obviously under the we rely on the evidence of Mr. Lewison, and in particular, as I understand it, there's no dispute as to the proposition of California law that's in issue. And that is set out in the judgment, and I was going to come on to that at paragraphs 97 to 105. which is where the judge deals with this alternative basis.
Yes.
And so there was the evidence, and I think we don't need to go through that actually in detail, because the important thing is that the experts agreed as to what the proposition was, and it's at the top of page 136 of the judgment, that, as recorded there, it was not in dispute between the experts that, as Mr. Sosnicki said in his paragraph 30, the equitable doctrine applies only where the plaintiff's claims are dependent upon or inextricably intertwined with the obligations imposed by the contract containing the arbitration clause. And it moved, so that was agreed between the parties' California lawyers, and the question was how that applied to the facts. And that's the part of the judge's judgment which I understand to be challenged at paragraphs 106 to 107. And the judge's reasoning at 106 to 107 relies both on the application to the Mexican Trademark Office, but also on the question of whether the claimant's claims of trademark infringement and passing off are dependent upon or inextricably intertwined with the obligations imposed by the 1997 agreement.
Now, if they're not bound by the agreement, the answer must be no, mustn't it?
Well,
if the agreement's got nothing to do with them,
well,
then it can't affect their trademark claims, can it?
Well, in my submission it can, for the reasons given by the judge at paragraph 107, which is that in order to bring the claim for trademark infringement and passing off, the claimants have to rely on the trademark registrations and their goodwill, and those things are effectively protected and would not exist were it not for the coexistence agreement. And the point is that that's because of Clause 2 of the coexistence agreement, the 1997 agreement, which under which Santa Barbara, my clients, consent to the use by the Beverly Hills Polo Club of the name and marks worldwide, and agrees that they can register the marks worldwide. And so the judge's point was that if it, absent that consent to use and registration, then the claimants wouldn't have any marks or goodwill, because they wouldn't have been able to use them.
That? How can you possibly know that?
Well, because, for example, looking at the pleading, which I'll just turn up quickly because I appreciate that I'm running out of time. But if we look at the pleading, the particulars of claim, which are at tab 7 of the bundle, there's set out starting from paragraph 2 on page 74 are the UK and European registrations.
Yeah.
But if we look particularly at, for example, page 80, paragraph 14.10, reliance is placed on the use made of the UK mark and the logo which commenced in 1993. And sorry, I think there was an earlier reference to the use made in the EU that I should have pointed out as well, which is at 14.1 on page 77. And those particulars of use are under the heading Goodwill, Reputation and Enhanced Distinctive Character. That heading relates both to the rights in passing off and the trademark rights. And that the judge's point, which I submit is correct, is that the claimants wouldn't be able to rely on this use were it not for the agreement that allowed them to coexist.
But if they're not bound by the agreement, why couldn't they?
Well, but
their
the point,
entitlement to use the marks was never tested. Or rather, their predecessor's entitlement to use the marks was never tested. It was all part of the settlement agreement. So, if the claimants are bound by the settlement agreement, then I agree that the settlement agreement is going to play a large part in the adjudication of the claims. But if they're not, bound by it, then I can't at the moment see how the judge can say that the claims are likely to depend on the protection given by the 97 agreement. It assumes that they are and uses that assumption to say, oh, well, then they're stopped.
Well, it certainly depends on the use of the marks, and in my submission that's clear from the paragraphs that I've shown, my lord and my lady. And the use of the marks is obviously not just the use by the claimants themselves, but the prior use earlier by the predecessors in title, which would include the parties that actually signed the agreement.
Yeah.
So in my submission, it's not. My lord can't just look at the use by the claimants. You have to go back further, because that is what the claimants have done in their pleadings, and they've done it for important reasons, which is they are going to want to say, we were using this before you.
Yeah.
And so that earlier use in my submission is going to form an important part of their claim. And the earlier use is obviously relied upon, and that is dependent upon the use by parties to the agreement. Without getting into estoppel and so on. I mean, the other point, just for completeness, is that at paragraph 35, there is a reference, and this is back in tab 7 under in the particulars of claim, page 89. There is a reference to the use is said to be without the authorisation or consent of the claimants, and there is a reference to the 1997 agreement.
Yeah.
Now, I'm sure my learned friend would say that's because they are foreshadowing the defence that they think we're going to raise.
Yeah.
But the point is that in trademark infringement and passing off, you obviously have to show it's done without authorisation or consent. And so they do address the agreement. So I won't. I think I've made my points on estoppel, and I won't say anything more about that unless there are questions. I think I've got about 5 minutes, my lord, on the clock.
Yeah, something like that.
So that turns
Might
to.
give you an extra 5 if I'm generous.
I might not want an extra 5, my lord. I might.
So
Right.
we're on to ground 1, are we?
So we're on to ground 1, which is the third route, and the
Yeah.
third route assumes that English law applies, i.e. we're wrong in our primary contention that California law applies. And we've already looked at the fact relating to the Mexican trademark, and we need to look again, although my learned friend's already taken.
So here the judge is applying English law.
He is applying English law in my submission, and he applies it at paragraph 42.
Yeah.
He does so, I accept briefly, although obviously the reasoning starts at paragraph 33, where he makes it clear that he's looking at English law.
Yeah. And what's the principle of English law that he's applying?
Well, in my submission, he's applying the doctrine of approbation and reprobation. And the reason I say that is because that is the point that he raised with the parties during the hearing. And
just out of interest, did you suggest to him that he should be applying English law, or quibble when he indicated that's what he might be doing, he might be thinking about doing? Because that would cut across your entire thesis.
No, I didn't. I'm afraid I did what the advocate tends to do, which is take any bone that is thrown by the court.
If he was applying English law, he would have been wrong, wouldn't he?
Well, my primary submission, and I did make that clear at the hearing, and I think it appeared from the parts of the transcript that my learned friend took my lords and my lady to, was that California law applied.
Yeah.
But I did.
How then can the question who is party to the Californian contract be answered by applying principles of English law, whatever those principles happen to be?
Well, my lords, it would be on the basis that my learned friend is correct and that English law applies, and we would say, well, if English law applies, then...
No, he doesn't say that. He doesn't say English law applies to the contract. What he's saying is that the law applicable to the intellectual property rights is the law by which you decide, are his clients bound by the arbitration agreement? I don't think he's suggesting that English law applies to the question, or rather, English law applies to the question, who is a party to the contract? It's a different question.
Well, my lords, that may be correct as things have now transpired. I think perhaps it's fair to say at first instance things were not quite so clear.
But nobody suggested until the judge picked it up that the claimants were actually parties to the agreement.
No, and in my submission, and I think that this is consistent. Well, in my submission, that the judge was applying the doctrine of approbation and reprobation, and in my submission that, assuming that was the doctrine he was applying, then it might have been better for him to say that the claimants were bound by the agreement, as opposed to saying that they were a party to it, and that perhaps would have been a clearer way of expressing what he was saying at paragraph 42. But in my submission, looked at in the light of what my lords and my lady have already seen in the transcript, that is what he was doing, because he is saying that they did so in order to benefit from the terms of the 1997 agreement. And effectively, you can't have your cake and eat it. I mean, they wanted to benefit from the terms of the 1997 agreement, which is why they relied on it in Mexico. And the judge was therefore of the view that they couldn't take the benefit without the burden, and that was effectively the doctrine of approbation and reprobation, and that applied under English law. I mean, I'm not sure I can make the point in much more detail. My learned friend did take you to the relevant parts of the transcript. What he didn't take you to, I think, was the part of the transcript where he had another go in reply and didn't address this.
I mean, the judge is clear throughout on this finding. He's finding that they are parties, not just that they're bound because of some principle. Even if you look at 106, where he says, and this is where he is dealing with the US equitable estoppel argument, he says at 106, the claimants represented to the office that they were parties to the agreement, which I have found to be the case. I mean, he's not misspeaking. I mean, this whole part of his judgment is talking about who are they actually parties.
My lord, that is absolutely the words he uses, and it's fair to say that the doctrine of approbation and reprobation is a little bit obscure, and whilst I would express it by saying they were bound, perhaps to say that they were parties is not such a terrible misnomer when applying that doctrine. But he was clearly troubled by the fact that they had taken the benefit without taking the burden, and therefore his finding under English law was as is set out there. But I'm not sure I can add much more to my submission than I've already made clear. And obviously, I've already addressed the other point under English law, which is at the annex to my skeleton argument, which is the point about the Trademarks Act that my learned friend hasn't addressed you on, but it's my submissions are there in writing. Unless there's anything else I can assist my lords and my lady with, then those are my submissions.
Thank you, Miss Lane. You do wish to reply, Mr. Simpson?
My lords, if I may, I have 6 hopefully quite short points.
Yeah.
I don't think they should take very long. The first one, very briefly, just in respect of the Peterson, the reference to Professor Briggs' work, Civil Jurisdiction and Judgment.
Sorry, the reference to?
Professor Briggs' work, Civil Jurisdiction
Briggs,
and Judgments,
yes.
Authorities, tab 7. And the reliance my learned friend placed on the passage in page 155, the one that begins by contrast. I think there was a discussion between my learned friend and your lordships and your ladyship about where what the contrast was being drawn against. In my submission, it's the immediately preceding paragraph that begins just at the bottom of 154, which begins with the language "consider the case in which the claimant is subrogated to the contractual rights of another," etc., and then goes on by contrast.
Right.
In both cases, they're dealing with subrogation and insurance contracts, and so in my submission that doesn't assist. The second point in reply relates to my learned friend's submissions about the law of the assignments, or what the proper law of the contract of assignment might be between the various proprietors of trademarks over time. In my submission, whatever the relevant law of those particular contracts was is irrelevant. That law governs the relationship between assignee and assignor. They might govern things such as what happens if a party doesn't pay the amount they're supposed to pay for the assignment, or if the assignor doesn't comply with some obligation to provide documents for submission to a relevant trademark registry or something of that nature. It does not, as is the only thing relevant today, have a bearing on how the assignment has an effect on obligations owed to third parties by the assignee or not. That, for the reasons I gave in my submissions, depends upon the law under which the trademarks are registered. The third point in reply is to address a proposition that came out of the Egazarian case. And my Lord Justice Lewison, you and my learned friend engaged in a discussion about the language will or may, and does not or does not simply mean in paragraph 17. I think the proposition was discussed that it might indicate that the principle that Mr. Justice Burton was expounding on in that case was that there is a principle within the law of the contract, and potentially additive to that is some additional law that may arise because of the circumstances in which someone took rights or something to do with another basis on which it said they might be bound by that agreement. In my submission, that isn't what Mr. Justice Burton was saying in the case. In my submission, he was saying that will or may used language in that slightly broad way because there will be circumstances in which the alternative law, the law that needs to be applied arising from the circumstances that are said to bind a non-party, coincides with the law of the arbitration agreement. And I think paragraph 18 at point B, it's off page 217, apologies, I should have taken you to the authorities bundle, it's page 77 of the authorities bundle, makes clear in my submission that Mr. Justice Burton, Mr. Smuer and Mr. Justice Burton's approval of his submissions wasn't discussing an addition to the law of the arbitration agreement. He was discussing the only law that should be applied. So at B, you see, just as the proper law of the contract would not apply to issues of agency, so too it would not apply to whether there's been, as a matter of German law, a merger between an old company and a new. So at least that example shows that he was considering circumstances where the law of the underlying contract had no bearing on when or if another person was going to be bound. Point 4 in my reply addresses the relevance of registration of prior rights that may have arisen by contract, and my Ruritanian land example. My submissions do not depend upon an obligation to register rights. My land example was intended to refer to a non-registrable right, so it was a monthly license, so a non-registrable right, but that's of course only an analogy. More importantly, in respect of the trademarks, my proposition is that there is no basis to say that an assignee of a UK trademark is bound by some contractual right that may have arisen as a consequence of an agreement that its predecessor or one of its predecessors entered into. And I say that because, as was part of the discussion during my submissions, trademarks are personal property. That's a matter of statutory definition of what they are. transfers of personal property do not take with them burdens that a previous owner had caused to exist. There is a special case in respect of trademarks where some rights can be registered, and such as a license. If a license is registered, then a person who takes the trademark afterwards will be bound by that. But that's a special case where someone is bound. It isn't the only case when someone may be bound. And in this case, there's no suggestion there was any registration. In fact, my learned friend says, well, the coexistence agreements in issue here are not even capable of being registered. So someone who takes personal property without knowledge of previous rights and without any other reason to bind them to the contractual arrangements that their predecessor entered into isn't bound by those arrangements. Fifth, penultimate point is about my learned friend's submissions on the estoppel point. As I understood her submissions, they focused on what had taken place in Mexico in 2015. As I think I may have skirted round, but maybe not set out fully in my submissions before. The judge did not rely upon the circumstances of the Mexican communications in dealing with estoppel. He only relied upon his earlier finding that the claimants had become parties to the 1997 agreement. So there was no consideration by him of whether those acts in Mexico were inextricably intertwined with the claimant's claim, or the claimant's claim was dependent upon those activities. So his basis for finding an estoppel wasn't one my learned friend advanced before you today, and there's no respondent's notice. So it's not in my submission before the court to consider that set of submissions. And then the final point in reply, of course, unless I can assist the court any further with any other issues that might arise, it was suggested by my learned friend that, again, under the estoppel head, my clients were not able to rely. So my client's claim was dependent upon the 1997 agreement because they were not able to rely upon use, and because they need to show no license, no permission. Both of those propositions are answered by the point that I say my clients weren't bound by the 1997 agreement. That's a simple overarching point in respect of both of those suggestions. But in respect of the alleged ability to rely on use depending upon the agreement, in my submission it's relevant to point out that my learned friend took you to the particulars of claim. The allegation is use began in 1993. The contract that my learned friend says permitted that use was agreed by another party in 1997. It's impossible for that contract to have permitted that use to have commenced or taken place. And so the submission that that my client's claim is dependent upon that agreement in one way or another, in my submission, is one that should be accepted. So, my lords, my lady, unless I can assist you further, those are my submissions in reply.
Thank you very much, Mr. St. Quintin. Well, thank you both very much for your very interesting arguments. As you will not be surprised to learn, we will reserve our judgments. You will get a draft judgment in the usual way in due course, which will be your opportunity to correct our English, but not our reasoning, or to argue the points. We would hope that in the light of the draft you will be able to agree an order disposing of the appeal. If you can't agree the form of order, please make short submissions in writing, and we will make the form of order that we consider to be appropriate. Thank you both very much.
Thank you, my lord.